Hi, Lisa.
Hi, let me just turn my camera.
Hi, everyone. Welcome. Thanks for joining us today. Hi, Lisa. Are you there? Hi, Lisa.
Hi, sorry. That's,
Hi, how are you doing today?
oh, it's a very rushed morning, so I'm huffing and puffing, but hopefully
Yeah.
I can contribute meaningfully
Middle
to
of the
this.
week. Plenty going on at the moment.
Yeah, you can see I'm still perspiring.
Yes. Well, thanks for joining us today for our second live discussion. We're looking forward to having a great discussion with you today. Hopefully, we can share a lot of important things with our followers. I see Leanne's joined. Daniel is here.
Yeah,
Hi, Leanne. So to begin, I'd like to introduce myself for those who don't know me. I'm Ariana Dwyer. I've been a team member of Marsh Fidelity for almost a year now. I started in June last year. Um, I'm really enjoying the team that we have at Marsh. So at Marsh Fidelity, we're a Durban-based fiduciary business. We specialize in estate administration, will drafting, and trust formations and management. And we're based in KZN. We were started in the height of COVID in 2020 by our founder and director, Daniel Marsh. We're a team of three. It's me, Daniel, and Leanne. And our purpose can be seen in our mission statement. We aim to create an enduring difference. And for us, this means going above and beyond the administration requirements required for deceased estate administration and trust management. So, what's important to us is clear communication and bringing clarity to people, to our clients who are in pain and are vulnerable at this time in their life. So this is why we partner with people like Lisa, who have similar values and a similar mission statement. So let me introduce quickly Lisa, who you met in our last live discussion. Lisa is an advocate of the High Court. She was admitted in 2008 as an advocate, so she has extensive legal experience, and she's moved now into the legal teaching space. So she has the Lisa Thomas Legal Academy, where she teaches young professionals who would like to enter the legal space about the practical things about practicing law and some of the challenges you may face and the challenges regarding admission and becoming a candidate attorney. And she provides many free resources on LinkedIn to her followers, provides much value there, educating about legal terminology and the practical side of law. Lisa, would you like to expand on that?
yeah. I think you pretty much covered it. So to give everyone the elevator pitch, I kind of went the other way around. So I um, started at the bar, which is not advisable. So from the LLB, I went to the bar, did my pupillage and practiced for a while. Then I went into law firms after I left practice, and then now I find myself in the teaching space. So if you want to look at it, it's kind of it can be seen as a devolution, but I see it the other way around because I've actually found uh, my sweet spot within the legal space. And I think without having had all the prior practical experience, then my teaching would just be theoretical and I'm not about theory. So as Ariana said,
Very much so.
I have various avenues through which I teach. The first one being LinkedIn, which incidentally also started during COVID. Um, so that has evolved to where it is today. And you're welcome to follow me on LinkedIn. And then I've also started my academy out of the content because there was obviously need for a little bit more in-depth legal education, and so I just keep on going from there. And as Ariana has also touched on, my values, I'm very very big on ethics. I suppose you could call me whistleblower material. Uh, because I just, actually, especially within the legal space, the professional space, there's a lot of intellectual dishonesty that goes on, actually from the university level. So I'm also, part of my mission, I guess, is to awaken law students, graduates, aspiring legal professionals to that reality that, um, ethically need to be a certain way. And of course, there are unethical elements in the profession. And for me, I'd rather be right, or I'd rather be ethical than be popular. So I don't think I'm very popular amongst my colleagues, but be that as it may, at the end of the day, if you're an ethical person, then your conscience is clean. So I'm very happy. I've been following Marsh Fidelity for maybe just over a year, and totally resonate with how they handle the most, sensitive, I think, arguably the most sensitive part of someone's life, and that is the issues around their death. And I just admire the care and the love and the empathy that goes into not just winding up in a state, but also preparing people to die, which is not something we like to think about, but of course it's a very necessary conversation that we have to have, and to have it in the hands of qualified professionals is something that should give clients and prospective clients the utmost peace of mind when it comes to planning their estate and also administering a deceased estate.
Yes, and you do a great job of imparting this love of ethics and the importance of it in practice on your LinkedIn through the posts you share. And it's so important to impart that on young professionals who are just entering, their legal career, who may see a different side from other individuals that they come across. So you do a great job of that. And that's why I found you a few years ago when I was in my CA journey as a candidate.
Yeah.
And that's how we met.
Actually,
And
it's actually a nice full circle
yeah,
moment, and
it's a lovely
I
story
think,
of how you shared that with me. And now we share it as well. We share similar values.
yeah, yeah. I mean, I'm very very happy to be doing this with you to see, and also to see, how far you've come since your CA days, and to be able to treat you as an equal. I'm really really happy today to be doing this with you.
Thank you so much. So today we're going to be discussing some very important topics regarding estate planning. So as Lisa briefly mentioned, estate planning is a lifelong journey. It's not just getting a will drafted and then putting it in your drawer for the next 10 years or until you pass away. That's not estate planning. Estate planning is an ongoing process. You need to update your documents and make sure it aligns with your current values and life, your stage of life. So we're going to be talking about the legal requirements for a valid will, and then things that aren't legal requirements but are advisable to include in your will. Just from our experience, the things we see cause pain for our clients when they don't take these things into consideration during their estate planning. And then estate planning documents, important documents to have during your estate planning that will make the process so much more streamlined and less pain caused throughout it. Do you have anything to add there, Lisa, about the topics before we begin?
I'm very new to this whole Instagram live thing, so if I'm a bit on the formal side, just bear with me. I know it's a very informal thing, but yeah, I think from my side, my experience with estates is obviously because I worked at a law firm, it dealt with when the person actually died. So it wasn't actually helping them plan. It was, I think, I would call it doing damage control. Because they'll come to you, it's a very sad time and you have to handle it with care. And obviously you don't see that in an attorney's office. So that's I was faced with it. I had to learn on the job. Being an advocate, I didn't do all this kind of thing. So I had to learn how to fill out the forms and how to, what were letters of authority and executorship. And so all of my estates training pretty much came via that. And I speak out of that experience in terms of what not to do and what should be done, which is why, again, I appreciate Marsh Fidelity's existence, because it's not something you take lightly, and it's not just business as usual when it comes to estates. And yes, I've also participated in Wills Week. So the firm would put itself down for Wills Week. I participated in two, and the one year basically handled it by myself. So I must have drafted like 8 simple wills in one day. So that was also a crash course for me in terms of drafting a will and sitting with a client and reviewing it and changing it and things like that. So um, I'm very I'm very cautious about that process of drafting the will. I don't think it's something that you can do pro forma, and I don't think attorneys know the legalities surrounding it. And of course, in brushing up my knowledge for today's live, I was just going through the textbook, and there has to be, there are formalities in terms of the person that's making the will. Like certain things have to be in place, and the document itself, so for to be valid, certain things have to be in place. So I don't think attorneys in general have take that, do that due diligence and take that care to figure out, okay, does this person have another will? Are they of majority? Is it their intention to make a will? Are they doing it of their own accord? Like someone just pitches up and says, I want to do a will, and they do it, right? So, and of course, when it comes to the document itself, it's very much copy and paste, which is not how you should treat somebody's estate, no matter how simple or how complicated it may be. So I think going through the nitty-gritty of the formalities, it's not just to be legally compliant, but just to be, those requirements are there so that people's estates are not mishandled and their truest intentions are, truest and fullest intentions are expressed in the document, because when they are gone, they're not there to explain it. So, and of course, in terms of the second point, there are things that you guys have come across, which I haven't come across. So again, I'm here to learn as well. That you guys have seen firsthand the pain that clients go through when something hasn't been canvassed and included in the whole. So again, you have the legalities, and I think even when attorneys do know the legalities, it's like we're doing it just to be compliant. We're not doing it because we care for the client. We're doing it just so we can pass the smell test and the legislative smell test, and just for it to look right on the surface. And then if there are any problems that come up, they're not going back and saying, okay, how can we review the way we draft our goals? We need to include this and include that. Mm-hmm. So I'm very much looking forward to that second part, because you can tell me from your experience what have been the issues that have caused pain, and how have you all addressed it in terms of bringing it up with future clients. And the last part of the talk is
important estate planning documents.
Yeah, so like I said, from my side of things, it was just gathering, the stuff to wind up the estate. So they weren't actually involved with planning your life. Estate planning is not just to do with death. Estate planning is your life. So it wasn't. They were barely doing the bare minimum in terms of handling the deceased estate file. So you can be rest assured the planning side of things was non-existent. So, but again, you guys have come up with some innovations that, again, I'm totally on board with. And as much as I have my stuff to contribute, I'm also happy to learn. What are in your guys' opinion on the ground? Like, what are those important planning documents? So you can take it away, Ariana.
Definitely, I agree. We agree. There's definitely so much more care that's required than just drafting a document that meets the legal requirements. You definitely need to consider the client's full situation in life and how that could potentially affect, their loved ones. This is what we're doing it for, to provide for their loved ones and make sure that their
Yeah,
wishes are carried out when they are no longer here. So it definitely involves a lot more consideration than just meeting the legal requirements. That's why we've included the sections about estate planning documents, things that can make the process a lot easier for your loved ones and less
yeah,
painful. All right, so then I think we can begin with the first topic, which is the legal requirements for a valid will. So the importance of having a will that meets all the legal requirements cannot be overstated. It's the most important document, not the only important, but the most important document to have is a valid will. So the first requirement is that it needs to be in writing. So this, in terms of the law, means typed or handwritten. We advise our clients to have it typed, your will to be typed,
yeah,
not handwritten. But if it is handwritten, it doesn't exclude it. It just means there may be more additional requirements that the master requires, such as
yeah,
something to prove that it actually was the person who was making the will, that it's their will. Someone
yeah,
maybe stating an affidavit to say this was the testator's will, and they did in fact sign this themselves and write it in their handwriting. This is their handwriting. But then in cases where there may be a dispute about the will, then you would maybe even have to need an expert in handwriting to confirm that
yeah,
as well. So
yeah,
this also means obviously that at the moment audio or visual electronic wills aren't advisable, aren't accepted in South Africa. You need an original will that is written, typed or handwritten. So that's the first point. And then it needs to be signed by the testator. So the testator is the person who's making the will. They will sign that it is their will. And a female is called a testatrix. So I'll be referring to the testator quite a bit in this discussion.
yeah. I'm a stickler for that. So
Just for those who don't know of our followers, that the testator is the person making the will. So the will needs to be signed at the end of the will by the testator. So if we dive a little bit more into this means, so signing includes the making of initials or just your normal signature, but it can also include, only in the case of the testator, they are allowed to make a mark, which may be like a cross or a thumbprint, but then
yeah,
there's additional requirements involved there if they sign by making a mark. So that would be that a commission of oaths has to be there when the testator and the witnesses sign to confirm that that actually was the testator who made a mark. So, and then if if the will is only one page long, then you must sign at the end of the writing. The testator needs to sign at the end of the writing, not anywhere on the page. It must be specifically at the end. And if a will is more than one page, then the testator can sign anywhere on all the pages except the last page, and that page must be signed at the end of the writing, as with a one-page will. And then the next requirement is that two witnesses must sign. So two competent witnesses. They must be above the age of 14 years old and competent to give evidence in court if it would be required. And then the last requirement in terms of the Wills Act is that the testator must be 16 years old or older, and they must be able to mentally appreciate the act that they are doing by creating a will. And these requirements are all there for good reason. They are all
yeah,
very important. But like we said, there's so much more than just these requirements.
yeah. I mean, just from what I dealt with. I mean, all wills that we drafted for clients were, you know, typed out, and they were given a copy. Or if they wanted the original, they could take the original away with them, and we kept the copy. But what we did have often was this issue of a secondary will popping up, and then you got to get handwriting experts, and I think for me, it really highlighted that opening phrase of the will to say this will cancels out. We sort of take that as for granted, but I know dealing with my culture, there's often big dramas when it comes to wills, and more often than not, there's some kind of secondary will that surfaces, and then you have to deal with that. And of course, it's legit, it's typed, it looks really ancient, and sometimes you find that the attorney that drafted that will, if it's an old person whose will it is, you can't find that attorney. That attorney is dead or out of practice, and so you're going to go through this whole process of hiring a handwriting expert and proving that it's a valid will, and it's just so there's that. I mean, just having it in writing doesn't, it is the preferred method, but you can have all kinds of other documents, and other kinds of testamentary documents, the codicils and other things. So sometimes you have to like put together a puzzle and figure out which documents go together, which will is the most recent one, and of course deal with the forgery, the consequences of a forged will. So that's just, I guess that's just from my experience. It's good to have it in writing, but I think attorneys especially, they really put on the back foot when they haven't drafted the will. So they're often at the mercy of the family, where they'll say, okay, they'll bring the will in, or if they had the will from another attorney that they were keeping for this client, it's like they don't look at it until the person dies, and if you haven't drafted it, then it becomes difficult to understand sometimes. So I just think when it comes to drafting a will, I think it's a little bit easier when you are the one that drafted it, and you had a prior relationship with the testator. And of course, the other things are pretty, like you said, there are good reasons why the testator has to be, 16 and above, and why the witnesses have to be 14 and above. It's just, I think it's similar to like an affidavit where you only have the document to go on. So if those people are signing, the assumption is that they are, they have the capacity to sign as a witness. They have the capacity to make the will itself. And so whoever's going to execute that will has to be satisfied that what's on the face of it is, that the people that did it and witnessed it have complied. In terms of witnessing the will, I've had, we dealt with it very impersonally, that we sort of go to the office next door and get those people to drag the poor testator, and they don't know these people from the above, but they'll say, oh, we just need you to witness the will. And that is the most impersonal, cold thing you can do. I mean, if this person's like, whether it's a huge estate or it's a small one, like just one asset or like some jewelry, you gotta treat it with respect. You don't get a total stranger, just to sign as a witness. I think that for me was a big no. Because when there is a problem with the will, now are those people, like you said, are they going to be coming to court and testify if the will gets sued on? And the big answer there, or the obvious answer is no. Because in my view, the attorney just saw signing again as a formality. So he or she didn't expect that the will would eventually get sued on, or that there would be some kind of dispute. So again, I think choosing your witnesses are very important. I think the whole signing of a will is very important, especially if you are the one that's drafting it. And I think it has to be done with a certain level of reverence. So, you gather the witnesses that the testator wants. You prepare yourself. And I mean, of course, the commissioner is going to be someone that's unknown because that's ethical. You can't get somebody that's known to the testator to commission the will. Um, but this whole thing about witnesses, like, because they might have to come to court at a later stage, you don't want to get people from the shop next door, the owners, or, somebody at your office, the secretary signing the will. Like, you want to tell the testator, who do you want to witness this? I mean, it would be the same thing like with a marriage, right? Like, you got to have two witnesses signing the marriage register. Like, you don't want the janitor signing it of the church and some random person in the crowd. It's a special time, so you want the people that are going to be witnessing it, their signature is going to be there forever and ever. So you want, it's the same level of reverence, I think. So I think choosing the witnesses is very important. And of course, the person has to appreciate the work or what they are doing. And that goes down obviously to intention and this thing about volition, free will. So they have to know, they can't be coerced into, you need to make this document, and this is what, and someone telling them what it means and why it's important. I think it's something that has to come from the person, him or herself. And they must know why they do it. And of course, the earlier you make the will, it means that you have to obviously update it as your assets increase. If you get married, if you have children. So making a will early is advisable. But of course, that means like it gets kept at an office like yours, and Daniel mentioned that you guys phone and check if things have changed,
Yes.
so that you can update the will. But of course, if you're 16 and you know what you're doing, I certainly didn't know what I was doing. I didn't even know that I wanted to do law. So if you can make a will at 16, that's great. But I think people really, when it comes to age, they really wait. They feel they have to wait, and Daniel and I touched on this in the last slide. They feel they have to wait until they get to a certain age, and like death won't come, or they're still young, And I think COVID just knocked that out the water, and all the post-COVID illnesses that we're getting now, people in their 40s dying of strokes and things like that. So I think while you can make your will at 16, if you fully understand what it's about and what you're doing, you shouldn't also put it for much later. And I dare say even people in their 40s don't understand what a will is and what it's supposed. You just know, you just put all of your stuff there and it gets distributed. I mean, it's far more complicated than that, right? So I think this whole live, doing all these lives is public education, because we want to tell people that it's more than just, it's more than just I'll wait till I get some assets, and it's just, the will is just there to make sure they don't fight over my stuff. I mean, that's why we need people like you guys. We have to explain this because there's a whole lot more that goes in, and it's a whole, let's just say you need to respect yourself and what you worked hard for, and understand that all of that needs to be protected, and your loved ones have to be, not just to prevent disputes in the event of your death, but they have to be cared for. So ideally you're going to be leaving them some money, right? And you want them to get a hold of that money as soon as possible, and for them to maintain more or less the same kind of life that you did with that person was living. So I think that whole the issue of when you make a will, I think the earlier you can make it, the better, provided it's 16 and above. But you also shouldn't wait to say, oh, death won't come to me, or I don't have a lot of assets. I think that's what people also say, and I've come across some really basic estates, which I always maintain is just as important as somebody with, a business person that has a very complex estate to deal with. And, so some people will say, oh no, I don't really need a will because I've just got a car and a couple of pieces of jewelry. But I've seen people take the time to put that into a will. And of course, that must be treated with respect and administered properly when the time comes. So, yeah.
Yeah, definitely. That is such an important point to note, is that a will is for any stage of life. It's not only when you are contemplating death, because you never know when that could happen. It could be tomorrow for anyone.
Yeah,
So,
that's the joke of it, right? It's like we think we know when we're gonna die, so we'll make a will just before. I mean, it's like I guess we all have to see that we're gonna live forever.
yeah.
But I mean, the very fact that it's not even certain means that you should do it as soon as possible. And as your life changes, change it. Like update the will. I think that's something people need. I think that's something you guys do well, is checking in on people. Because let's face it, the average person is not going to think, okay, I had the child. They're not going to think. They say, oh no, I have a will with the attorney. It's all set in stone.
Yeah.
So having that follow up is also important as your life changes. And I think maybe you're going to touch on that later in terms of what should it be included in a will. Because if they fail to update it, I'm sure there are consequences, right? Like in terms of if it doesn't reflect their current estates and they die with an outdated will, so to speak, that certain things are not catered for, people are not protected. So I think you'll come to that in the next part of under the next topic.
Yes, definitely. I agree completely. Having an old will that hasn't been updated and doesn't take into account your current life circumstances, it can actually do more harm than good, because there are
Yeah.
provisions in place with intestate succession. So when someone dies without having a will, your estate will be distributed in a certain way, which is
Yeah.
deemed the fair way. But if you have an old will that doesn't take into account your current circumstances, it causes a lot of pain for the loved ones that you have if they are not taken into account, and someone else who may have been involved in your life many years ago is now inheriting your estate.
Yeah.
So it can actually do more harm than good to not update your will. So I think we can move on to the next points, which some of which you actually briefly touched on, whether you know it or not, in your current discussion that we just had. So the first one is adding the date of the will. So this isn't a legal requirement, but it makes sense to add the date of the will because it allows your executor and your family to know whether it was your last will and testament. So that's so important. And the place of
I think that habit should come from actually like drafting legal documents like pleadings and stuff. I think in that case the rules require you to have the date, and it just makes nobody has to tell you.
yeah,
And especially with a will, like a will is, I would say, essentially time sensitive. It's dependent on something, an event in time happening. So how do we know when you did it, whether it's the most recent one? I mean, that will be the biggest issue, right? Whether if in case you have a few copies floating around and all are not dated or some are dated and some are not, you're going to be sending your attorney or your executor, put them chronically on grandpa, trying to figure out which will is applicable. And so really now just you don't have to have a law that
yes,
says
it seems like
I
common
mean,
sense,
yeah,
but it's not
I mean
actually a legal requirement for.
when we learned to write letters in primary school, that was one of the components of a letter was you put the date under the addressee, like because you have to know at what point in time the document was created and how much more importantly for someone's a document that's basically summing up somebody's life and giving directions about how their stuff is to be distributed. So I just think some things are just it's just common sense.
Definitely. But it's actually more common than you would think for people to forget to put the date on. And then if you, like you said, if you have multiple wills and they're all
Yeah,
not dated, then you have to take into consideration all of the wills and see which um, parts of the wills actually work together and which don't. Some portions may have to be deleted if they don't work together in that
and so
case.
you end up putting your attorney on grandpa or tornado while they figure out like which parts to chop off and which parts are valid and which parts have been forged. And I mean, it's just put the date, people.
Yeah, I don't think there's too much more to say about that point. And then the next point is the witnesses to sign should sign every page of the will. So this isn't a legal
Yeah,
requirement. They are only required to sign anywhere on the last page of the will. But it is good practice to ask your
yeah,
witnesses to sign every page.
absolutely.
Yes.
Absolutely. And I think if I'm not mistaken, the same person signs as the same. So if you have number one must sign as the same person, you know, number one on the first page must be number one everywhere else.
Yes. Don't
Um,
mix and match your witnesses.
yeah, yeah. So no, I would also, as a safeguard. I mean, this person's not going to be around for me to ask them, and I'm not going to go looking for the witnesses. And what if the will loses pages? Right? What if the pages go missing? So I would not just sign the first page or sign the last page only, but definitely, like all the work that I did was one and two, one and two, one and two. And if I remember right, I think it was, no, there wasn't a commissioner on the other pages, but it was the same two witnesses signing as number one, number two on every single page, whether it was one page, 2 pages, 10 pages. And of course, they must sign at the end, and commissioner has to verify their signature. So yeah, that I don't think that is as common sense, but I think if you are looking to protect yourself, I think it'd be more risk management or partly a
Yes.
risk management issue that you would, as somebody, especially if you've drafted the will for the client, that you would, even if it's one page, it's fine. You just sign on the one page. But if it's many pages, you make sure that the same two witnesses are signing throughout, and of course on the last page with the commissioner of oaths. Definitely, again, that's like besides the date giving you the place and time, signature is authentication. So if the testator doesn't sign, we're going to say the will is not valid. If the witnesses don't sign, but the testator signs, the will is not valid. So just let everybody sign on every page so that there's no doubt that if the page goes missing, you know, you can still sort of piece it together. That particular page was authenticated by the testator and by the two witnesses.
Definitely. And another thing to note about witnesses, it's also important to note that your witnesses should not be someone who is potentially going to inherit from your estate,
Yeah, absolutely. Yeah,
because that
yeah,
can cause problems as well.
yeah. These are, I mean, and also, like I said, the commission of oaths can't be known to anybody,
Yes.
right? So, I mean, it might seem, to maybe to a non-legal mind, some of these things might seem, oh, so what's the big deal? Um, if somebody is standing to benefit from your will, from your estate, then they have a vested interest in tampering with the will. They have a vested interest in signing the will. It's just in the same way you're not going to get, for example, an attorney, commissioning their own client's affidavits, right? There's just a conflict of interest there. So we're going to have to tell clients, if your son and daughter are the main heirs, then there cannot be witness one and two. You're going to have to get somebody else that is known to you, still known to you, still somebody that you trust. But and obviously, as the attorney, not very advisable to sign as a witness, especially because sometimes the attorney is the executor, and so there's a vested interest there that they're going to get
Definitely, yes.
3.5%. Yeah, so there are those, I guess, certain people that are excluded from signing as witnesses. But like I said, you can still be somebody that the testator is comfortable with, like people that
Yes.
because again, it's a very important document and it should be dignified by people witnessing the testator basically signing, authorizing that this is the fullest expression of their wishes, and it's a very important, very reverent thing in my opinion. So the witnesses can still be can still be people that the testator knows, just not in the ones that I mentioned.
Yes.
And there's probably more cats or more types of people, but I think in terms of the people that are involved in the will, the heirs, the attorney, the executor, uh, the commissioner obviously can't sign as witness, and the commissioner. So
Yes. So,
ethics.
so something we recommend if you want to go the extra mile with your witnesses is to
Yeah.
include a page that is not a page of your will, but it's included with your will that puts your witnesses' details, so their name, full name and surname, and their ID number. So the point
Mm,
of the ID number is to show that they are above the age of
yeah.
14, that a witness needs to be, so that no one can say they weren't 14 years old
That's
when they
nice.
signed.
That's nice. Because I mean, the will that I drafted, I think there was a place for them to print their names, or there was space on that below the signature line for them to print their names and maybe put their ID numbers there. But I think having a separate page is again a best practice thing, because most of the time you're just gonna get a signature which is not really something legible, right? So it doesn't really give a indication about the identity of the witness,
Definitely.
unless they're printing their name next to it. But I think even if they do print their name next to it, it is best practice to have that page just to cover your tracks.
Definitely. So the next point is destroying old wills. So if you are creating a new will, it is
Mm,
advisable to destroy any old wills that you have revoked, because the
yeah,
purpose of this is because all original wills or documents purporting to be a will need to be lodged with the master. So even if
yeah,
you have a current will, your old wills also need to be lodged, any document that was a will. So if
okay,
you, yes, and then those wills need to be considered together. If
okay,
for example, they're not dated or any
mm,
circumstance like that.
okay,
And also, then they become part of the public record once they are lodged at the master. So anyone,
mm,
including your family members, can see what was in your old wills as well.
okay.
So that's
Yeah, I
also,
think that's something we never. I was never party to that. Like I said, especially during World Week, when people are coming in off the street, so to speak. And so they just say, I want to do a will, and of course you do them the simple will, which is what it's restricted to. And we never ever asked that question, like, do you have another will? We never asked that question. I think just to go back to that phrase, that all this will revokes and cancels, other wills, like existing wills. I think that phrase is taken for granted, and I think nobody. I think they take it for granted also that if the if another will exists somewhere, that phrase is just like a bazooka. It's just going to diminish or exterminate those wills. But I think that's a very good practice point, that someone is coming to say they want to draft a new will. Um, even I mean, even if they're coming to you with their parents and their parents want to draft a new will, chances are the parents went to another attorney. So you're going to say, and you don't have the time to go and look for that other attorney whose office might have been closed down. So you also tell them, if you have any other rules in place, please bring it along, because they have to be destroyed. Failing which we're going to have to lodge everything. Uh, And the last thing you want is when you're about to lodge the estate and another will surfaces, because you get a family member trying to block the estate from being wound up or whatever. So I think that's something that I wasn't involved in, but I think it's just to make sure that along with that phrase that the will opens with traditionally, that it's not a catch-all. So it will cancel it by words, but if a physical will still exists out there, then they have to be um, wrangled and destroyed.
Definitely, it's just good practice to keep these points in mind. And then, obviously, if you have minor beneficiaries, so children who are going
Yeah,
to potentially inherit, or children who are mentally not able to look after their own affairs, it's so important to include a testamentary trust clause. So I think you
yeah,
touched on this in your last live discussion with Daniel,
yeah,
the
we did.
parents'
Yeah, we did.
estate planning. But this one cannot be overlooked. It's so important, because if you have a minor beneficiary and they're set to
Yeah,
inherit from your will, that money is going to be held by the guardians fund, which is
yeah,
administered by the government. So unless you want to deal with the government for 18 years and have someone that your family doesn't know, you know, looking after your minor child's inheritance,
yeah,
even potential grandchildren that could inherit, it doesn't only have to be your children, any minor that's named in your will. It's so
yeah,
important to have this clause because this will kick in. This clause will kick in when you die, and then your will basically function as the trust deed for the testamentary
yeah,
trust.
yeah. Yeah, I mean, I think this is part of the misconception. People say the belief is that if you don't have a will, that the money goes to the state. I think this is what people refer to when they mean that, when they say that if you have small children, minor children, and they are not, you don't have a testamentary clause in your will, that the money will go to the guardian's fund, which you said, like you said, is administered by the government. And then when once they reach 18, they've got to put in, or the executor's got to put in a claim on their behalf. So, and of course, they don't, minor children, I mean, no one really takes them seriously when it comes to wills. Um, Especially when you have the first pays arrangement. So no one really thinks that maybe the child is going to die, or the stated grown child is going to die, and that the person under them are going to die, and the person under them, that might happen. And then what's going to happen if, for example, a grandchild or a great grandchild um, stands to inherit by that arrangement? So you have to have that clause. Um,
Definitely.
and effectively hold that money for them in trust until they reach that age. I just think it's good. What you would call, like, to put it crudely, after sales service. Like the minor child who will eventually become a major must be able to come to the person who drafted the will and say, right, or go to the executor who will bring them to the attorney or to people like you and say, okay, we want to invoke the testamentary clause now and, put in a claim so this child can inherit. So very important. Detail, nuance, but very important nuance.
And another point to note about this trust clause is that it should contain sufficient detail describing what the purpose of this testamentary trust would be if it would be created. So, and also naming your trustees, your nominated trustees for this
Yeah,
trust. That's also so important because these are people that your beneficiaries are going to have to deal with. You
yeah.
want it to be someone that you know and trust, and someone who's qualified as well and experienced, who knows how to run a trust,
Mm.
preferably. And then the next important one, obviously, is very important, is your executor, choosing your executor and obviously trustees
Yeah.
for a potential testamentary trust.
I think
So,
we could have, I think based on my very first, and Daniel and I were discussing doing these lives. I mean, I could have a whole series to choose an executor
yes.
based on what I've seen. So
So
just, I'll let you talk a bit and then I'll give my points.
I don't think I'm going to go into too much detail on this one because it was
Mm.
covered in your last live.
Yeah,
We
yeah.
are running short of time here, but
I'm
I can't
watching.
understate the importance of choosing your executor. Not only someone that you know and trust, but someone who
Yeah,
is also qualified and experienced, who knows how to do estate administration. Even if you have co-executors, one can be a family member, someone that you know and trust, and have a
yeah,
professional on board as well as a
yeah.
co-executor. That's also an option. I don't know if you have
Continue.
anything to add
Oh
on
no,
that point.
I'll just add a small part to say, and this might complicate it for the man on the street, but your attorney doesn't necessarily know how to administer an estate. So the default is if they don't have anybody that's their family trustworthy or competent family member or friend or colleague, then they'll choose the attorney. And from my experience, I know it makes it difficult to pick an executor, but I would say to the public, don't take it for granted that your attorney knows how to administer an estate. So again, you want to keep that in mind. And if you are going to choose your attorney as an executor, make sure that they're qualified, or alternatively, you can, take the will elsewhere to people like Marsh Fidelity, where you can have the peace of mind that they are qualified fiduciary professionals. So your will is not lost in a practice, in a law practice. It's actually dedicated to that business. So, just don't take it for granted that your attorney knows what to do.
Definitely. That's such an important point because many people nominate either an attorney or a financial planner who hasn't actually studied estate administration and doesn't do it as
Mm-hmm.
their main work. So they may not
Yeah.
be up to date with the law surrounding this, the practice of this work. So then I think if you don't have anything to add there, we can move
Yeah,
on to the
we can
estate
move on.
planning documents.
Yeah.
Um, so obviously your will is number one. That's the most
Mhm.
crucial, but it needs to be updated regularly to correspond with your current life situation and your
Yeah.
wishes. There's no point in having a will for, 10 years that hasn't been updated. It can cause more harm than good. So that's the most important to note about a will.
Mm. I
And
think that's what most people tend to do, is think that it's a once and for all thing. Um, and that might just, I don't know if it's equal to not having a will, but like you said, it can be more harmful in the long run if your will is not updated. Because what happens to the part of your estate that doesn't get included in your will? So, I mean, would you have to lodge testate and intestate, you know? So it just makes it a whole lot more difficult. So, and I think this section is really important because people also think it's just a will.
definitely.
Estate planning just involves a will. And so if I have my will, I'm sorted. But I'm sure that there are those other very, very important, you uh, the file that you have to have.
Yes.
I think you guys call it the life file or
Yes, you're
something.
leading on to my
Um,
next point with that. Yeah, so a life file is basically a document where you keep all your important estate information. So you would put all the information about yourself, your beneficiaries, and then include any documents that are important to your estate planning. So title deeds, marriage certificates, all
yeah,
your insurance policy information, medical aid information, anything that could be of significance for your estate administration, because all of these things need to be dealt with when you pass away. And not having access to all those documents causes delays and it causes pain for your family because now they're sitting wondering how this estate is going to happen and it's taking longer.
yeah, yeah. And I was doing some research yesterday, and one of the documents that popped up being one of these important ones is what happens when you are incapacitated, like you're on life support or you're brain dead. So I think they call it advanced healthcare directive, where you document outlines your preferences for medical treatment if you become incapacitated or unable to communicate your wishes.
Yeah.
Sort of like a
So
I don't know if that's something that you guys include in the life file.
yes, we do actually do that. It's a separate document, so we call it a living will. It basically
Okay.
advises your medical practitioners and your family members what your wishes would be if you were in that situation and you
Okay.
can't actually consent to any procedures or to be on life support.
Yeah.
Yes. So that would be a living will. It is something important to include in your life file as well if you think you might have specific preferences in that situation.
Mm.
Definitely, that's a good point. Thanks for mentioning that. And then another document that we think is very important is a letter of wishes. So this isn't a legal document. It's a
Mm.
document that
Yeah.
sets out your hopes and your dreams for your family, what you want to see, with their inheritance, or not even with their inheritance, but just like your wishes for their life and any words you'd
Mm.
like to pass on. The value
Yeah.
of this when you pass away can't be overstated as well. It's to see in your own
Absolutely.
handwriting, in your own words, that word that can bring so much comfort to your loved ones.
Yeah, I think we touched. I think Daniel and I touched on this the last time in the context of the testamentary clause.
Yes.
Um, so if you're leaving money for minors or for those that are minors at the time that you die, when they open, maybe you write each beneficiary kind of, a letter to say, this is the money that I set aside for you, and all your, like you say, all their wishes for each person, and what they wanted to do with the money, and etc. etc. I think that's just it's a nice touch because the will can be a very cold document.
Mm-hmm.
It's very administrative. It's very official. And yes, we talk about reflecting the wishes of the testator or the testatrix, but it's the wishes in terms of the legalities, not the wishes in terms of, what's in their heart and what they're feeling, and why they are giving certain people certain benefits and what their thoughts are behind it. That is not within the ambit of, Section 3.2 of the World Act. Okay, you don't put, you know, wishy-washy, marshmallowy stuff. Okay, you just stick to the legalities. So I think having that letter as part of the estate planning documents, it just adds that nice touch. And I think people have reading out of the will. Some people they all gather and they'll read the will out. I don't know if we do it here. I've seen it on TV. But we can that letter, those letter of wishes can be read out. And I think when everything is said and done, it doesn't, and the legalities are taken care of. It really brings closure
Mm-hmm.
to know that this is why X, bequeathed something to you or donated something to you, why they put this testamentary clause and what they wanted to do with the money, their hopes and dreams for your future. I mean, it's just, I think we cried because we're like, wow, like they were gonna die, but they thought about my life. So I think it's a nice kind of squeeze of cream and cherry on the top when it comes to estate planning. Because when you die and that letter is read out, and I think that will matter more than the will and the money. You'll say, wow, they actually took the time to write this letter to go beyond the scope of the will and let me know what they think. So I think that's a nice that's a nice touch, and I think it's also good closure for people that are mourning. You don't want to be cold and administrative, but you want to leave them with the wishes of their loved one.
Definitely. It's a very personal document. And like you say, it brings so much closure and comfort to them in that time, knowing that you thought about them and what you would like to see in their lives. Well, thank you so much for discussing with us today, Lisa. And thanks everyone for joining. I hope it was very educational and you learned a bit about us both and some useful information. We look forward to seeing you all again sometime. We will announce a future live if there is one. We haven't discussed that yet. But thanks so much, Lisa, for joining us today and everyone
You're
else
welcome.
that joined.
Thank you for having me. And I'm sure there will be more. We'll just work. We'll just work on the finer details. It was a pleasure chatting with you and of course learning. I'm always here to learn as well as contribute. So I enjoyed it. Thank
Thank
you.
you so much. This has been recorded, so the video will be posted if you didn't catch the whole live discussion with me and Lisa today. Thank you so much, everyone. Have a good afternoon.